from. That's the language of the Act, and that's the language of the commentary. Your Lordships may first see Section 4. Few sections. 101, my lord, it starts, volume 2. Is there a tab? Well, let me first see 4, which is at page 107. Well, the only reason I'm showing it, I'll show some commentary on this later, is this is the waiver provision. It has some relevance in our case. A party who knows that any provision of this Act from which the parties may derogate. So, there are provisions in the Act from which you cannot derogate. The word derogate is used in 2 sections of Part 1, Section 4 and Section 34. So you cannot, so my lord, this section and Article 4 commentary, which I will show later, recognizes there are some provisions which cannot be derogated from. Then your lordship sees 5, which is the extension of jurisdiction, just for the sake of completion. Then please straight away come to Section 11, which is at page 110. 11 is titled Appointment of Arbitrators. This is based on Article 11 of the model law. And what the other side relies on, my lord, is 2. Subject to subsection 6, the parties are free to agree on a procedure for appointing arbitrator. Lordships have seen that. Then 6 is where the appointment is made. When an application is filed, parties to request the Supreme Court or the High Court. 6A, your lordships have seen in a different context, my lords, earlier in the NN Global saga. But please come to 8, because we rely, my lord, on 8. 8 is post-amendment, and therefore the Law Commission report becomes relevant insofar as 8 is concerned. The Supreme Court, or as the case may be the High Court, or the person or institution designated by such court before appointing an arbitrator shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1, 12(1), and have due regard to. So, now this is something which is deviant from the procedure. And have due regard to qualifications required for the arbitrator by agreement of the parties, and B, the contents of the disclosure and other considerations as are likely to secure the appointment of an independent and impartial arbitrator. So, my lord, 11.8, and it has been judicially also held by this honorable court, by your lordships, that you are required, I would not even say, my lord, you are it's a discretion. You are required to deviate from the procedure to ensure that the tribunal that you appoint under 11, the court, is an independent and impartial tribunal. So, my lord, 11.8 is crucial for our purposes. I will show some the Law Commission report on that, and, my lord, some commentary on that. This, in my view, is something which Core has completely missed. 11.8 has not been noticed. Then, my lords, may go to section 12, which is at page 113. 112. This will be elaborately argued by, my lord, various others here. I'm just touching on it. 12 is grounds for challenge. This has been amended drastically after the 2015 amendment in view of the Law Commission report. 12 has been substituted. My lord, various disclosures are to be made. And then important is 12.5 at page 113. This is de jure ineligibility. Notwithstanding any prior agreement to the contrary, any person whose relationship with parties or counsel or the subject matter of the dispute falls under any of the categories specified in 7th schedule shall be ineligible to be appointed as an arbitrator, provided parties may, subsequent to disputes having been arisen between them, waive the applicability by express agreement in writing. So, 12.5 talks of about 7th schedule ineligibility. The Lordships have interpreted this in a number of judgments with this proviso. So 12 has to be read with 11 because 11 now 8 requires a disclosure by a prospective arbitrator, which wasn't there earlier. So now when the matter comes, say, before your lordships under section 11 or before the High Court under section 11, if such a panel is to be operated, they will have to make a disclosure of whatever relationship they have. And independent of that disclosure, your lordships will ensure that there is an impartial and independent tribunal. So the moment that burden is cast upon the on the court, my lord, then there is a problem with these panels, which are unilateral. There's no problem, my lord, with a panel of an institution or an independent panel. So, my lord, 12.5, 13 is the challenge procedure. I'm not troubling your lordships. 14 is failure or impossibility to act. That is de jure. Your lordships are familiar with that. Then please now come to one other portion. In fact, I was very happy that the learned SG had highlighted that portion in his written submissions because we were also intending to rely on it. Please come now to page 115. This is something which has been hinted at in some of the judgments, but not spelt out. Well, chapter 5 is sections 18 to 27. Two sections here are crucial to my submission, my lord. First is 18. Conduct of arbitral proceeding 18. Equal treatment of parties. The parties shall be treated with equality. This is one part. And each party shall be given full opportunity to present this case. Noted in the learned SG submissions as the Magna Carta of arbitration. And, my lord, which we will show that this equal treatment principle applies even at the stage of the composition of the tribunal. And that will make good, my lord. So,
of course, the chapter heading says conduct of arbitral
right.
proceedings.
But the commentary, my lord, and particularly section 21 has to be read with 18. 21 suggests, my lord, that the commencement of the arbitral proceedings starts when the request is given. Your lordships are familiar with 21. So the appointment of the arbitral tribunal actually comes after that.
Absolutely.
And, my lord, the idea is simple. Whatever contractually you've agreed. But once you are before a quasi-judicial body or a substitute for the court, then all rules of fair play have to be there. You should be before somebody who's independent and impartial, and you should be treated equally. So, my lord, our submission is 18 squarely applies, and we'll, my lord, show that. So, this is one separate portion of the act which has really squarely not been considered. It's been hinted at in a couple of judgments, but it's not been considered. 18 and 21. And then, my lord, just to complete this, please now come to 34. 34 is at page 121. As your lordships know, there are two limbs to 34. One is party and one is, my lord, public policy. The two portions I want to show, which are of some relevance, my lord, is 34.2a2 and 34.2a5. An arbitral award may be set aside by the court only if the party making the application establishes on the basis of the record that the arbitration agreement is not valid under the law in force, law to which the parties have subjected or failing any indication under the law for the timing in force. So, arbitration is not valid under Indian law as a ground for setting aside an award. And more, my lord, pertinently, 34.2a5. There's some very interesting commentary on 2a5. The composition of the arbitral tribunal which is what we are, my lord, now looking at, or the arbitral procedure was not in accordance with the agreement of the parties, this is party autonomy, unless such agreement was in conflict with a provision of this part from which the parties cannot derogate. So, my lord, this is the second place in the act where the word derogate is used. So, even if you have an agreement between the parties and that agreement derogates from a mandatory provision of part 1, the award can be set aside, or failing such agreement not in accordance with this part. No, that's the other position where there is no arbitration clause. What I must mention here, there is a 3-judge bench judgment which is a little problematic. I'll come back to it. So, these are the sections which are relevant for the purposes of our limited issue of unilateral appointment of a panel. Before I go to the 4 judgments, may I now just invite your lordship?
Mr. Banerjee, just before we leave this statutory provisions, this chapter 5 is conduct of arbitral proceedings.
Correct.
Now, only by virtue of what is contained in section 21, you are saying that it will also relate to not just conduct of the proceedings, but also the commencement and composition of the tribunal.
My lord, I will show your lordship some commentary on this very Article 18, which suggests that the composition is also covered by 18. The heading, no doubt, seems to suggest.
Yeah, heading is a little misleading.
But
yes, what you are trying to
is
say.
Absolutely right. But I will show, that's why I wanted to mention, my lord, I will have to establish that this provision is relevant for the composition stage. And that, my lord, we will establish by the relevant, my lord, material.
Now, which are the non-derogable provisions of the part in regard to composition?
Right. Now, my lord,
that's section 12.
My lord, I would say 11.8,
12.5,
11.8, 12, 18 for our purposes. My lord, in fact, there was a very long debate in the working group. They wanted to make a list, but they didn't make ultimately they didn't make a list. They said it is to be this thing. There are 2 judgments of our court, one on 12.5 in Harsak and one on section.
Forget all the judgments because we are a constitution bench. You argue as a matter of first principle.
So, my lord,
12.5. Let me look at which judgments fall in line with what we are ultimately inclined to.
I understand. 12.5, my lord, is mandatory.
12.5 is mandatory.
12.5 is mandatory. 18 is mandatory.
12.5.
12.5 read with 11.8. Because, my lord, 11.8 refers to 12. So 12.5 read with 11.8 and 18, according to my lord, submissions, are mandatory, and the commentary also says so. There are various other provisions which are mandatory, but it is not necessary to enumerate the complete.
Now, I'll pose to you a hypothetical. Any arbitrator cannot fall within the degrees of prohibited relationship, if we can use that expression, which has been spelled out in the 7th schedule. Now, what if one of the clauses, what if the arbitration agreement provides that one of the parties shall appoint? Can such a clause be made consistent with 12.5 by saying that the persons whom that party appoints should not in any way be in breach of the 7th schedule? Will that then be a provision which will be in conflict?
Mulot, the answer there is, Mulot, unilateral.
Is unilateral appointment itself by itself?
That is
contrary to the provisions of the Act.
Yes, Mulot, because
one is that any appointment which of an arbitrator who is in conflict with the 7th schedule is absolutely a non-derogable provision of the statute. But does the Arbitration Act itself frown upon unilateral appointment per se?
Well, Lord, that is how your lordships have interpreted it in 2 judgments.
No, but forget the judgments for a moment. Well, Lord, where did we get that? Where do we identify the?
Yes. Well, Lord, I identified it, my lord.
And trace it only to 18.
I identify it in this fashion, my lord. It flows from the amendments made pursuant to the Law Commission report, which frowned on unilateral appointments. The Law Commission, therefore, my lord, I want to show that, and I want to show the amendment, particularly 11(8).
So now that you have formulated shown us the statutory provisions, what you can do is this. You now formulate your points. You formulate your submissions. Then we will go into then we go to the 4 judgments, the Law Commission report. So you can just formulate your submissions now.
Right, my lord. My lord, my submissions are, my lord, I am only on panel because there is no challenge subject to correction.
You are only on
Panel, my lord, unilateral panel. My lord, because I know your lordship has asked me the question whether unilateral appointments are, my lord, are eschewed generally or not. But
suppose the railways, for instance, says that, look, we will have a panel of people who are not connected with us at all. We have a panel.
Absolutely. My lord, I have to answer that.
We have a panel of retired judges.
We have a panel of impeccable, my lord, integrity,
etc. Is that permissible under the statute?
Right. My lord, according to us, no. And I will formulate 4 or 5, my lord, under 4 or 5 heads.
All right. Now, why don't you just take the next 3 or 4 minutes and formulate your submissions? You can we've asked you a question right at the beginning, but it will help us to formulate your points. If you want to read your written submission, we can read your written submission.
That will come to there are 4 grounds on which, 4 different jurisprudential grounds on which,
my lord. Just formulate that.
There are 4 jurisprudential, my lord. One is that a panel unilaterally appointed by one party.
One thing.
Control, you want to mention control? My lord, the better word would be unilaterally controlled by one party. A panel unilaterally controlled by one party, my lord, would fall foul of section 11(8) read with section 12, in that it would not be independent and impartial. This is the first, my lord, first ground. 11(8) read with 12.
In that it will not be
an independent and impartial tribunal. It may be impartial, but it is not independent. It will not be an independent and impartial tribunal, which is a non-derogable, my lord, facet of arbitration jurisprudence. It has to be independent and impartial. Otherwise, the entire, my lord, edifice collapses.
But independence, is it a quality in the arbitrator or is it in the process of appointment?
It's in the process, my lord. I will show, my lord, there's a very nice paragraph. I will show, my lord. Independence is qua, my lord, the clause, my lord. We are not on individual arbitrator.
The argument could be really that you must avoid an appearance of bias, not just actual bias.
Right, my lord. The actual bias we are not alleged.
So far as to say that, well, I'm aggrieved because this particular panel which they have appointed is suffering from lack of independence. But the fact that one party controls it
is, I will show, my lord,
the principle that there must be it must generate confidence in the arbitrating parties. It must generate a sense of credibility.
I have 4 heads under which your
not just actual bias, it's an appearance of bias which must be avoided.
One is the bias argument. My lord, I am on the
independence argument.
Independence argument, because if your lordship sees 11(8), my lord, one is disclosure, bias, etc., and just show 11(8) again.
It will not be an independent panel.
Yes. So, my lord, this is an important question, my lord, because let me not put it very bluntly.
And one more sentence you can add there in your first proposition, that a panel which is exclusively controlled by one party, according to you, suffers from a lack of independence.
Right. This is, my lord, proposition 1.
For that, you will have to drawings from 18.
18 is separate.
Able to draw
18 is one more. This is, my lord, 11 read with
18 is limited in its scope.
18, my lord, 18 is, my lord. Secondly, any clause which, my lord, does not. Your lordship has that exactly the question Justice Roy put to me, limited in its scope, my lord. I will satisfy your lordship on that separately. The second limb, my lord, it's a second ground on which I put. There are various, my lord, 4 grounds we have formulated.
Independence may be also looked at from the perception, because now we're not talking about a lack of independence to challenge an award.
Correct.
All right. Just as when you challenge, say, a judgment of a court on the ground that the judge lacked independence,
Correct.
the threshold is very high. That the judge had some interest in the
Well,
subject matter or was connected to the parties to the dispute,
Correct.
so on and so forth. But independence at the stage of composition is a matter of perception.
And-
Because you are entering into a judicial proceeding, which is arbitration is a substitute for a judicial proceeding. So when parties are entering upon arbitration, it is their perception of an independent adjudicator or lack of independence, which is crucial. Because you must create conditions which foster a sense of confidence in the
In
process.
fact, 3 phrases, my lord, have been.
Whether in fact that person was eventually independent or otherwise begs the
What
question.
happens in these cases, my lord, all the 4 cases before your lordships are railways and railways connected cases. From time immemorial, they have something called clause 64. The problem here is, my lord,
So independence at the stage of composition is not an objective test of whether someone would or would not be biased, but the perception of a party
of
who is
independent.
accepting
Correct. I am obliged.
that perception must be that of an independent adjudicator.
Absolutely. My lord, in fact, 3 phrases are used in judgments: major objective, paramount consideration, and important consideration. A paramount consideration is independence. Just show me. Of confidence so far as our arbitrators are concerned. If you have such a panel, the result both ways is bad. If the panel appointed by one set of one party decides in the favor of that party, the other party always has that lingering doubt that Mr. Banerjee was appointed on the railways panel, so therefore he has a predisposition.
No, but the other, look at it from the side of the public sector.
The other problem,
Look at it from the, we must look at both sides.
no difficulty,
A public sector organization always has this fear that, look, I mean, look at what's happening in the arbitration.
Correct,
It will be taken
now
from
you
around,
see-
we'll have a 20,000 crore award.
Now you see this one-sided panel story. Now the one-sided panel, Mr. Banerjee now gives an award in favor of the contractor. Now, immediately, my lord, all sorts of issues arise there, may be genuine. So, my lord, the solution is not a one-sided panel. The solution is staring in the face, my lord. The solution is an independent panel by an independent institution. That is why we are crying hoarse that we should have institutional arbitration. The problem is not the individuals in the panel. The problem is who makes the panel. The moment today, my lord, both ways you lose.
Not saying that we need independence and full stop. The problem is arising, what is the criteria? What are those principles on the basis of which we are going to determine that there is lacking of independence here?
My lord,
Everybody agrees that they have to be
the
independent.
very fact, let me put it this way, my lord, the very fact that one party is appointing somebody, my lord, is unfortunately enough, because, my lord, what was arbitration? Arbitration was where both parties had confidence in the individual. Here you are basically putting up a list and asking one. So there will never be any confidence in that list of the other party. One of the articles said unloved and unappreciated panel. One party puts up a panel.